Hello and welcome to the lecture of International Business Environment. In this lecture, we will going to move towards the Unit 16 of Settlement of International Trade Dispute, which is Block 4, Unit 16. Topics we will going to be covered are Introduction, Areas of International Trade Dispute, Methods of Settlement of International Trade Dispute, Role of ICC in arbitration and conciliation, major issues in the settlement of international trade dispute, overview of Indian Arbitration and Conciliation Act 1996. So yes, in this session we will have a discussions about the trade disputes. If we talk about the trade disputes is mainly the dispute arises in the trade practices. These kind of a disputes could be arises by the omissions of any functioning or a proper functioning of a contract, or they may be a kind of a breach of a contract by one of the party. There may be any kind of a differences arises between the party. अगर मैं trade dispute की बात करती हूँ तो trade dispute mainly होता है जब हम किसी भी तरह की trade में आते हैं. So उसमें arises होने वाले जो भी conflicts होते हैं, जो भी issues होते हैं, that was basically comes into trade dispute. Trade dispute mainly concerns with the conflict arises between the two parties और उन conflicts को कैसे resolve करना है, उनके कुछ mechanisms are basically used. International trade dispute और international business के अंदर भी इस तरह के conflicts and issues rise up होते हैं. जैसा कि हमने discuss किया था इस block की starting में कि laws इसलिए बनाए जाते हैं कि हर एक issue या हर एक conflict का एक proper mechanism हो. Again, there is always a requirement to minimize this conflict. इन conflicts को minimize करने के लिए हर चीज हर mechanism का use किया जाता है. So handling those trade dispute with the help of we can say that legislation or with the help of arbitration or conciliations, these are all the one of a method which are used for that. कि एक trade को एक business को उतना ही ज़्यादा friendly और comfortable दोनों ही पार्टीज के लिए बनाने के लिए that was comes into the settlement part. So it is one of that method जो कि आपकी practices को rightly perform करते हैं and yes at the same time they performed as to settle the disputes. So dispute को settle करने के लिए भी they worked as one. Now the areas of international trade dispute. If we discuss about the areas of international dispute, so dispute होने के बहुत सारे reasons होते हैं. There are n number of factors due to which disputes are arises. So now the question arises, what are those situations in which that disputes are arises? So very first is dispute arises when the contracting party do not fulfill their contractual obligations resulting in the breach of contract. दोनों पार्टीज हमेशा किसी ना किसी तरीके की कॉन्ट्रैक्चुअल अग्रीमेंट में आती हैं. यस देयर इज अ कॉन्ट्रैक्ट बिटवीन दोस पार्टीज जिसको हम लोगों ने प्रॉपर लॉ भी बोला हुआ था और जिसकी एक्सप्लेनेशन हमने प्रीवियस सेशंस में दी थी. अगर उन क्लॉजेस में से कोई भी एक ऑब्लिगेशन अगर पार्टी फुलफिल नहीं करती है तो ऑटोमेटिकली दिस विल राइज टू द डिस्प्यूट. सेकंड, व्हेन द टाइम इज कंसीडर्ड एज द एसेंस ऑफ द कॉन्ट्रैक्ट बट द गुड्स आर नॉट सप्लाइड ऑन दैट पर्टिकुलर टाइम. अगर अगेन डिस्प्यूट के अंदर देयर वाज अ सर्टेन स्टेपुलेशन रिगार्डिंग द टाइम, अगर टाइम से रिलेटेड कोई स्टेपुलेशन है और वो फुलफिल नहीं की गई है, सो इन दैट केस ऑटोमेटिकली दैट राइज द डिस्प्यूट. व्हेन द प्रोमिसर एक्सप्रेसेस डिफिकल्टी ऑफ एन परफॉर्मेंस ड्यू टू सम कॉम्प्लीमेंट वी कैन से दैट कंटेम्पलेटेड इवेंट और डिलेज, किसी डिले की वजह से या किसी भी प्रोबेबली रिसोर्सेज आर नॉट अवेलेबल और देयर वाज अ टाइम टेकिंग प्रोसीजर, उस प्रोसीजर की वजह से अगर एक परफॉर्मर जो है वो अपनी नॉन परफॉर्मेंस को एक्सप्रेस करता है प्रॉमिसर की यस इट्स अ डिफिकल्टी टू परफॉर्म दैट पर्टिकुलर टास्क, तो वो भी एक तरह का डिस्प्यूट होता है. When a promiser pledge his inability to perform his obligation due to the failure of a third party, किसी तीसरी पार्टी की वजह से अगर एक promiser ये स्टेटमेंट देता है कि yes he or she is not able to perform that particular obligations जो कि contract में थी, so that will lead towards the dispute. इसकी वजह से भी disputes होते हैं. But when the promiser faces some unusual circumstances, अगर किसी भी तरीके की unusual circumstances probably industry में ही rise up हो जाते हैं, like strike हो जाए, lockout हो जाए या किसी भी factorial issues आ जाए, so उन सब issues में again there was not delay in the work, there is a delay in the commitment. सो अगर उन डिलेस की वजह से किसी भी तरीके के अनयूजुअल सर्कमस्टांसेस अराइज होते हैं और जो प्रॉमिसर है वो अपना प्रॉमिस पूरा नहीं करता है या that person is unable to meet his commitments, so in that case yes there is a reason for the dispute. Or we can say that these are all the areas in which the dispute may arise. When the overseas buyers wants to avoid the contractual obligations because the market of a goods has dried up and there are no demand, or he find it's difficult to locate the buyer for the goods order, that will comes into again in a dispute. कि overseas buyers अगर there was a delay, or we can say that कि अगर एक पार्टी अपनी contractual obligations को बिल्कुल avoid कर रही है, that will also lead to have a dispute issues. Another is when the overseas buyer refuse to pay or delay the payments of the goods. अगर payment delay हो जाए, अगर payment देने से refuse हो जाते हैं या they avoid to give that payment, so that will lead to again a dispute working. So these are all the different areas जिनकी वजह से dispute arise होते हैं. So that is what these are those circumstances in which yes certain mechanisms are required. Now when the goods as a promise not supplied according to the description, now this is what the techniques. अभी इससे पहले जो हमने areas को discuss किया वो area basically discuss कर रहा था about कि अगर कोई भी एक promiser party जो है वो promise fulfill नहीं कर पाती, but when there was an issue in the goods, like again it's related to the promiser part. Suppose the goods which are required as per the description वो अपने description के हिसाब से नहीं है, जैसा कि Sales of Goods Act में पढ़ा था कि इधर वो या तो उनकी जो सैंपल डिस्क्रिप्शन थी, सैंपल डिस्क्रिप्शन की अकॉर्डिंगली वो परफॉर्म्ड नहीं हुए हैं, देन ऑल्सो इट्स वन ऑफ एन एरिया इन विच द डिस्प्यूट में अराइजेस. व्हेन द गुड्स सप्लाइड आर नॉट फिट फॉर द पर्पस रिक्वायर्ड, जिस पर्पस के लिए, जिस रीजन के लिए बायर ने उसको परचेज किया था, उस पर्पस के लिए वो यूज नहीं हो रहा है, दैट इज अगेन अ फैक्टर फॉर द डिस्प्यूट. दैट इज the buyer and the buyer rely on the skills and judgment of the seller for that goods sold. Then another is dispute arises when the goods supplied are not on the mercantile quality. It is one of the requirement of a Sales of Goods Act. अगर हम Sales of Goods Act की बात करते हैं तो हमारा goods जो है वो एक mercantile quality का होना चाहिए. अगर वो mercantile quality का नहीं है, so in that case that things was lead to the disputes automatically. Another इससे पहले जो दो पॉइंट्स थे that was discussing कि maybe जो goods है वो according to sample या according to description नहीं है, तो it is written in the contract और एक promiser ने उसको apply नहीं किया, that is again a reason of a dispute. but ये भी एक reason होता है dispute का कि if the product quality or product features are not mercantile, वो mercantile नहीं है. So dispute may also arises due to passing of a property in a goods and passing of a risk on the account of the title of goods. Dispute तब भी arise होता है जब अगर एक goods के साथ risk factor attach है और आप उस goods की property को तो transfer कर ही रहे हैं, but yes at the same time उसके साथ वो risk भी transfer करें, that is passing of that property of a goods and passing of that risk also, both the things. Dispute arises also when there is a dispute between the contracting party arises not only due to the breach of contract or breach of condition expressed or employees, but also as on the breach of warranties also. अगर दोनों ही parties के बीच में किसी तरीके का dispute हो जाता है and one of the reason is कि दोनों ही parties में से किसी ने एक breach of पार्टी ने breach of condition और breach of warranty की है, so that will lead to the another kind of dispute arises between the parties. Then dispute may also be occurred due to the misinterpretations of a particular clause in the contract. Now this has also happened because when there was a clause put on the agreement, or we can say that जब contract में बहुत सारे clauses लिखे जाते हैं, so उस clauses में से अगर किसी भी एक clause को लेकर misunderstanding है, so automatically that is the one factor जिसकी वजह से एक dispute rise हो सकता है दोनों ही parties के बीच में. Another is dispute may also arises due to not complying with the stipulation on the shipment including the partner shipment, transshipment, packaging, labeling and marking etc. एक गुड्स को ट्रांसफर करते वक्त इट इज जस्ट नॉट अ गुड एंड इट्स क्वालिटी ऑफ फीचर, इट्स ऑल कंसीडरिंग जब हम इंटरनेशनल बिजनेस की बात करते हैं टू एक्सपोर्ट देम, टू शिपिंग देम, एट द सेम टाइम किस तरह से इंश्योरेंस की है, किस तरह से कॉस्ट है, कौन एक्सपोर्टर कॉस्ट बेयर करेगा या इम्पोर्टर कॉस्ट बेयर करेगा, किस तरह से उसकी पैकेजिंग है, लेबलिंग है, मार्किंग है, ये सब फैक्टर्स भी कंसीडर्ड होते हैं व्हेन इट कम्स टू ट्रांसफरिंग ऑफ the goods from one country to another country, because these are all formalities which have to be considered. तो ये भी एक reason होता है. This is one of a reason that dispute may arises due to not fulfillment of all that stipulation which are related to the shipment. वो सारी stipulations को आपने follow नहीं किया जो shipment से related थी. So that was comes into the arises of disputes. So ये अब तक जितनी भी हमने सिचुएशंस और सर्कमस्टांसेस को डिस्कस किया, दैट इज व्हाट इन किस तरह से इश्यूज होते हैं व्हिच आर रिलेटेड टू अराइज ऑफ द डिस्प्यूट कंफ्लिक्ट. नाउ व्हाट आर दोस मेथड टू ब्रिंग आउट अ सेटलमेंट इनटू इट, यानी कि हम इंटरनेशनल ट्रेड डिस्प्यूट में किस तरह से सेटलमेंट लेकर आ सकते हैं. फॉर ब्रिंगिंग आउट सेटलमेंट द वन ऑफ अ थिंग इज आर्बिट्रेशन. Arbitration is the alternative of dispute resolution, that is ADR. That is a legal technique in which the party are basically put in a step to resolve all that disputes. जब वो अपने dispute settlement के लिए perform करते हैं. So that is, it's a settlement technique in which the third party review the cases and impose a decision that is legally binding to the both sided. Now that is the entry of a third party in the arbitration. Arbitration में हम ये कहते हैं कि yes, third party involved in it, and due to this third party the settlement was occurred in that dispute. और जो भी third party का order होता है that all must be followed by both the parties. Arbitration basically बहुत commonly use होती है when it comes into the commercial disputes. जब हम किसी भी तरीके के business disputes को की discussions करते हैं, it's very commonly used, and use of arbitration is basically more controversial in the consumer and employment matter, because in that case it will be more good to enter into the legalized performances. So arbitration is not voluntary in that case. Now what are those advantages of arbitration? If we talk about कि arbitration के क्या क्या advantages होते हैं, the very first advantage of arbitration is that the arbitration proceeding can be commenced and completed within a specific time. Yes, जिस time पर वो dispute arise होता है and they demand for the arbitration, तो उसका एक set performing time होता है, उसकी कुछ proceedings होती हैं which needs to be followed. So the cost and expenses of the arbitration is comparatively less than the another method used in the solving that dispute. Another is advantage of that is the arbitration promotes goodwill and better trade relationship between the parties. Parties में एक better trade relation हो, एक अच्छी goodwill आए, that was the another advantage. Service better हो, expert advice होती है, expert consideration होती है, this is one advancement. And yes, at the same time एक privacy और secrecy होती है, that is कि publicize नहीं होती है, publications नहीं होती हैं arbitration matter की. Arbitration procedures are less formal and more flexible than the others method. तो ये बहुत ही ज़्यादा we can say that बहुत formal नहीं होता है, but yes, third parties involved, then they have their powers and authority to perform that, but it is not as formal, and yes, at the same time it's very flexible enough. Now next method of solving that dispute is the litigation. The litigation is basically initiated and completed according to the rules of the court. Court के rules के हिसाब से, regulations के हिसाब से perform किया जाता है. And yes, at the same time, it is a method by which the party basically resort to a court established by law. And yes, at the same time, it basically considered as one of the time-consuming and costly method. So there are certain limitations of litigations. The very first is court proceedings are slow in time, as it's a very legalized procedure, very formal procedure. So in that case, it's always take a time from the court side. And yes, it's a very slow and time-consuming process. the judge, the experts, and the expert of that field law may not be expected to have some expertise in that particular line also. So the expertise issues are also there. And the time and the date of hearing is again the issue which is need to be considered, that what time is provided by the law and what time was provided by the court basically. And yes, court proceedings and judgment being open to public, known business secrecy can be maintained, and in that case as such secrecy was not maintained as it maintained in arbitration. Litigation basically a very costly and additionally more difficult in the foreign court. तो foreign court में इसकी practices जो होती हैं वो और ज़्यादा difficult हो जाती हैं. So these are all those limitations in the litigations. Now the arbitration clause. Arbitration clause is basically used as in a clause in the contract that require the party to resolve their disputes. So ये basically वो clauses है जहाँ पर party सारे disputes को resolve करती हैं. And yes, that clause may or may not specify. So in that case जरूरी नहीं है कि हर contract के अंदर ये clauses mention हो that arbitration was occur within that specific jurisdiction. So that is what arbitration clauses. But all arbitration clause की बात करें, that all the clauses which are required in performing the arbitration's functions. Arbitration clauses are very often combined with the geographic forum selection clauses. Yes, जितने भी arbitration clauses होते हैं वो mainly जो है geographical forum से भी decide होते हैं. Because yes, if we talk about the arbitration practices, क्योंकि arbitration practices इसीलिए की जाती है just to bringing out or reduce the burden of the court. Court के burden को reduce करने के लिए arbitration practices होती हैं. That is why it is what having a geographic forum also. Geographically भी वो उतने ही divided होते हैं. And yes, the choices of law के accordingly भी इनकी clauses होते हैं. So both could be used for resolving that dispute, or one could be used for that particular settlementing of dispute. One forum or both the forum can be used. Yes, at the same time, arbitration clauses may be very challenging in the basis of the practices, क्योंकि there was a chance or there was a risk of the biasness from the arbitrator side also. These are the certain factors in the arbitration was considered. So yes, this is all about in this session. In this session we will now get an idea about how we will going to settle all the disputes. अब हम लोग किस तरह से disputes को settle करेंगे. For settling that dispute, it is one of the important to come up in the practice arbitration and litigation. So this is all about for the today. So thank you so much. IGNOU MOOCs.